Good morning, everybody. Thank you so much for joining me this morning. We're going to cover a fairly meaty subject this morning, which is DVSA investigations, removals and appeals, though we will be touching on other elements of regulatory proceedings that may impact your professional standing and your living, as it were, when it comes to these matters. Just a bit of housekeeping before we start. Well, first of all, introducing myself to those of you who don't know who I am. I'm Carly Brookfield. I am DIA's Chief Executive and Chief Executive of the overall DIA group, which also includes Diamond Advanced Motorists. A lot of my work now, other than the strategic leadership of the organisation, stakeholder engagement with people like Department for Transport, DVSA, all those kind of things, representation and lobbying, part of that representation work that I do is representing members at things like tribunals, in investigations when there's been a complaint that leads to an investigation by DVSA, and giving advice and guidance to members when they find themselves in these kind of situations. So as the largest UK organisation for driver and rider trainers by thousands and thousands of members, it's not a mark of the quality of our membership that we have more involvement in these kind of matters. It's down to the sheer volume. The more members you have, the more likelihood that you are going to have some individuals who have fall foul of that. So that's who I am. I'm going to talk about some of the work that I do in this respect today, just to let you know how to best kind of talk to me in this session. If you just want to leave comments and chat amongst yourself on this subject, stick your chat in the chat. You'll see that in your top toolbar or your bottom toolbar, depending on where you actually have things on your screen. If you specifically want to ask me a question, I'm very happy to try and keep an eye on those during the presentation. May leave some of the stuff to the end for efficiency's sake, but any questions that you've got, pop those into the Q&A if you would manage that. Normally, I have somebody else kind of helping me manage these, or a co-presenter, so we share the responsibilities between us. But as I'm flying solo today, just appreciate you keeping things in those two boxes so I can dance between the two. Hopefully you can all hear me. You can either say in the chat if you've got any problems, and I'll try and pick those up. If you can also look on your toolbar, there is actually also an emoji function where you can give me thumbs up, or show any other emotions that we've got as well. And so you can let me know how you're feeling about a certain subject or what we're saying as well by the show of those emojis. And sometimes I might pause to ask you questions and ask you if you agree with that, which normally thumbs up and those kind of things. So hopefully everyone can hear me. Hopefully you can see my screen. Any issues with that, as I said, pop it in the chat function and I will keep an eye on that one to make sure there's no breakdown in communications. Help from a soggy northeast of Scotland. I'm sorry, Ian, that you are not enjoying the sunshine that we have down here in the southeast today. I will definitely send it your way. Okay, so going to crack on. We've got about an hour on this subject. I'll talk for about 45 minutes, maybe slightly less than that. That will give me time to answer some of your burning questions. However, the big thing on this, these kind of things, it's interesting to see the industry data, see some case studies of what's happened to other people and how we handled that and how they handled that. But this is a highly individual process. So if you have any issues at all, any complaints against you, you feel there's an issue with DVSA are calling your professionalism into question, or anybody else for that matter, the moment you start having these issues, the best advice I can give you right from the start of this webinar is get in touch with us or whoever your membership body is. The sooner that we can get on board and help give you advice, the better. And it helps us help you avoid some of the pitfalls of some of these issues as well. It's an extremely traumatic time finding yourself to be the subject of a complaint. And I hope the majority of you will never go through this process. And I hope all of you here today never have to experience it. But some professionals do. Some of them find themselves in that situation, arguably by their own hand. Some find themselves in these situations through no fault of their own. And I'll go into where that occurs and how it occurs as we go through the presentation, i.e. things like malicious complaints and things like that. So I understand it's an extremely worrying and traumatic situation for anybody who's going into it. The majority of you, however, will not face this issue if, however, you are aware of the risks, because it can happen to the best of us to be part of this process, sadly. Okay, so moving on through the slides. So what we're going to discuss today seems like an awful lot. I won't cover everything in depth, but we are planning on writing a guide in this area because, frankly, there is an absence of really good guidance from DVSA on this. It's something I have lobbied for quite a long time, that the regulator should provide more information and more guidance on what to expect from these processes they do. My background is working in lots of other regulated areas, medical, legal, defending doctors and dentists. I worked for the largest organization in that space previously, working with people like the GMC. I've worked in education, teacher training associations, and I've also worked within financial services, another highly regulated area for professionals. So my exposure to how regulators work well and best practice of guiding professionals through a very traumatic and confusing process, I try and bring to bear here. And I think there's a lot of improvements that we can make to how DVSA gives guidance to ADIs in this situation and how they deal with matters in general. I have to say, personally, I am a fan of the current registrar in terms of what he's trying to do to make that. I shouldn't show that bias, but I'm going to give credit where it's due to try and increase the guidance that's available and have a fairer process in that respect. But historically, we fought a bit long and hard to even have things like 2 lines included in the letter that's sent to ADIs who are undergoing investigation, that they can have representation from their association. So there's still ADIs out there and rider trainers who don't realise that they can go to their national association for representation and support, and they think they have to go it alone. So one of the things we want to do is make sure that everybody has that guidance as they enter the industry, what to expect from these processes and where they can go to for help. And hopefully today we'll demystify some of this. So we're going to discuss the risks that trainers face, the ADI register, what that's all about, why does it exist, and why does it bring to bear on professionals in this space. Fit and proper, always an interesting subject. The industry code of practice and how does that affect matters of professionalism and that being called into account. The National Driver and Rider Training Standards, how those are brought to bear in these processes as well. We'll have a little look at some of the most recent statistics in this case. And we'll also have a look at the DVSA complaints and investigations process itself, so you understand how that works a little bit better. We'll have a look at removal proceedings. They're kind of included in that one above, really. We'll have a look at making an appeal. So if you're in the unfortunate space that you've already been subject to an investigation and removal proceedings, and DVSA have kind of said, yeah, don't really care what you say and what evidence you present, we think we've got a strong case to remove you and we are removing you, what can you do then? And it's generally the process of an appeal to the General Regulatory Chamber and to have a tribunal. There's a different process, however, to appealing a standards check result. So I'll go into that in a little bit more detail. And again, there's a different treatment altogether for something that is a criminal non-regulator proceeding, i.e. you're in trouble with the police, not just DVSA. If we've got time, we'll also look at some case studies, because I know from my time in medico legal that whilst the educative piece is supposedly the most interesting part of any presentation or features in any magazines about these issues, the doctors and dentists that I used to work with were far more interested in the case studies, that the real stories of who'd cut out the wrong kidney or chopped off the wrong bit and what happened when that happened. So case studies are really good in terms of looking at what really happens out there and how was it resolved or not, and what were the consequences of that investigation. So let's get into it. I don't want to scaremonger, but as the statistics will show, it's not a great threat to the majority of trainers, but you wouldn't believe the number of individuals that I have had to represent whose face says it all in terms of they cannot believe that they are in this situation. And I'd say a lot of them don't deserve, clearly, to be in that situation, particularly if they're subject to a malicious complaint that has no foundation. Or a process has gone wrong from DVSA's point of view, and that person really shouldn't be subject to a removal because they haven't necessarily done their job, and that can happen too. But it can and does happen to the best of people. It justifiably happens to the people it really should happen to. So rather than thinking of the regulatory process as being a massive bogeyman that shouldn't exist, we do want it to exist, because as professionals, we want to ensure that everybody that we're working alongside, and the profession as a whole, is regulated, so the right people are doing the right things in it. However, there are times that it happens to the best of people, and through unfortunate circumstances or misguided complaints or malicious complaints, people can find themselves in this situation, and it is devastating. It's a really traumatic process. Some people handle it well, some people it's understandably too traumatic. I have real concerns about mental health issues in this process. That's why we try to do our best to support people as much as we can in them. And that getting that help and guidance is really a deal breaker for a lot of people going through the process. Some people we can help really well. Some people don't take the advice and can't be helped, quite frankly. And some people don't know where to get the advice in the first place. But it could happen to you. There is the risk it can happen to everybody, even if you're the best, hardest working, most ethical, moral professional in the world. If somebody colludes and there is a number of complaints against you, or circumstances happen to you, you could find yourself in the situation. Knowing where to go for guidance and knowing what the process is and the pitfalls is really important. So the kind of regulatory and other risks that trainers face, as well as the general road safety risks and everything else that's thrown at you in the course of your career, are things like pupil and client complaints, regulatory breaches, as in breaching the ADI regs, and other regulatory issues, such as breaching the Advertising Standards Authority regulations, or fraud, or trading standards. There are other regulators in your space. It always makes me laugh as a business owner myself when people say, I came into this to run my own business so nobody could interfere in my business. I'm not sure there is a business, having worked in multiple sectors as a business owner, that nobody else interferes. That is a pipe dream. Somebody, a regulator or a customer who actually acts as a regulator on your business in many ways, will always have an ability to interfere your business. And as soon as people realize that, the better they are at managing those risks. So there isn't just a DVSA to worry about in terms of an ADI's regulatory breaches. Things like poor standards check performance and your tip report can lead you into, obviously, a situation where the regulator is looking at you closely and considering removing you from the register. Multiple failures to appear at standards check for whatever good reason that you may have, and I'll demonstrate that in a case study later on, can lead you to the point of being removed from the register. Claims for professional negligence, easy for me to say, misadvice, mistraining, and public liability claims are also a risk to you as trainers, and also to us as an insuring group, because obviously DIA offers the most comprehensive professional indemnity and public liability coverage in the professional trainer industry. So we've got a liability offering those policies as it is. You've got a liability under those as well, but obviously we have things in place to help defend you in those situations. And then you've got the other spectre of, sometimes, unfortunately, we see criminal proceedings being held against individual ADIs and rider trainers as well. We'd love to think it was a perfect world we were operating in it, but it's a world that is operated by human beings and involving human being customers. So there is always going to be multiple risks in that kind of world. The biggest governing thing that happens in our world is the ADI register. Your professional licensing comes from the ADI register, and it clearly has regulations attached to it. The register itself was introduced in the 1960s. Its purpose was to protect those paying to learn to drive and the public by making sure not only the pupil is safe and well served in terms of the standards of your professional training and has a safer outcome as a driver through that professional training, it's designed to also protect the wider public, that the people plying their trade as a driving instructor or rider trainer on the road are safe to do so and don't present any other dangers unnecessarily to other road users as well as the pupil. And it's also designed to protect the profession. If we don't have regulation in place for licensed individuals, then we would have a very unprofessional arena. You may not like some of the regulation or how it's applied, but when it comes to our own children and services that we engage in as a human being and as a citizen, we like the fact that other professionals are regulated. So we want to know that our doctors and dentists are regulated. We want to know that the banks are regulated. So we can't then moan then when we voluntarily enter a profession that is licensed, that there is regulation that goes with that. And it's designed to protect you, the professional, as much as the paying customer and the wider public as well. I'm not going to go into the regs in too much detail here because obviously as a professional, you will know about those from your training period onwards, and you will keep yourself appraised of the regs and any development to those by visiting the gov.uk information on this regularly, which you'll see the link there. And when we send around the presentation afterwards, you can click on that or you can just Google ADI regulations, and it's something to keep abreast of any changes of, but to know it in the first place is to be able to comply with it. If you don't know what's in the regs, arguably, are you compliant? So, keeping up to date of those is really important. However, that does become something that comes out in a process of interviews under caution or investigations or in tribunals when we're briefing people, is not necessarily knowing what they're supposed to be compliant with. And let me tell you, whilst I might have some sympathy as your membership representative and a pragmatism that says we can't know everything about everything all the time, a tribunal panel of judges has very little sympathy normally for a licensed professional who does not understand and hasn't even read the standards for their profession, nor the regulations as well. It just does not fly as an excuse to say, I didn't know that was what I was supposed to comply with. To be licensed is to be compliant. So knowing what's in the ADI regs is really important. Fit and proper is an area of discussion and controversy for some people. In a nutshell, the registrar interprets it as a personal and professional standards, conduct or behaviour that could be unacceptable in the eyes of the public and other professionals. It's not possible definitive, which is what makes fit and proper controversial in some quarters. There has to be some discretion to take into account the circumstances of each case. So fundamentally, fit and proper can be a grey area, and that's what a lot of people don't like about it. It's not a clear definition. There are some clear definitions if you look again at those ADI regs and what makes fit and proper. The code of conduct, the ADI code of conduct, which organisations like DIA helped write in the first place. But there is this grey area that makes people uncomfortable, as in they can get me for anything. The registrar has to have some discretion for things that have not come across their path before that are really important to regulate on in terms of protecting the public, protecting the pupil, and protecting the profession as well. If you could only regulate on matters based on what was written down at that moment in time and not taking account of emergence, different approaches in training or different contexts of training, it would mean that there would be some risk for both the pupil and the professional and the wider public in that. So that's why they have some discretion under fit and proper as well. However, we do engage in a regular discussion with DVSA about being clearer or giving better examples about what does fit and proper look like. But the ADI code of conduct is a pretty good start, quite frankly. And the ADI registrar's job is to make an assessment when your professionalism is called into account via a complaint or via any other issue that might be happening in terms of your professionalism. It's their job to make an assessment of the risk you're likely to pose to the public if you remain on the register. And that's the same when you go to tribunal as well. The registrar might have already made their decision by that point to remove you because they think you're too much of a risk to be on that register and hold the badge. A tribunal has to sit there and work out whether they think that the DVSA were right to remove in the first place and they were right about that risk, or whether they feel that the risk is not as great as DVSA are representing, and you can continue. So it's a big responsibility for both a registrar and for a tribunal for subsequent appeal to make those decisions, because the responsibility is on both sides to make sure that you're not having people on that registrar that call the whole profession into account and can present extreme risk. And if we're talking about sexually inappropriate behavior, violence, aggression, any of that, fraud, any of those things, these are serious issues that some trainers can present to people and have done. So there's a responsibility to the public, to other professions and the pupil, but there's equally a responsibility that you are not removing someone's livelihood without due cause. And that's the balance that gets called into account in both the investigations by DVSA, and they take that responsibility seriously, but it's a pivotal issue within a tribunal consideration as well. Is removing someone's livelihood and their professional status is a big thing to do, and does their risk as a professional outweigh all of those kind of issues as well? So it's a serious consideration. So fit and proper in terms of where does DVSA get their intel as to whether you're a fit and proper person? How do they make that judgment? So the sources of information that they will draw on, and this is triggered by normally a complaint or a series of poor standard check results or failures to appear at standards check, or your TIP report, your ADI performance report based on test data. When they have reason to believe that you may be a risk in your role, or you're not performing to the standards that are set out for the industry, they will look for further sources of information to back up that feeling and make sure that they're doing the right thing, quite frankly. So validate the process of investigation. So the source of information that they will look at is your original application forms and any information you give on those. So, making sure that you disclose everything you need to disclose on your original ADI application form and on your renewal forms as well. Any DVLA records, i.e. they have direct connection to the DVLA database in terms of motoring offences. They are notified of any motoring offences as soon as they are handed down to you. And frankly, anybody who is still labouring under the misapprehension that you don't have to notify the registrar of a motoring offence is foolish, quite frankly, because not only do they know that you've got a motoring offence, if you don't notify within 7 days, which, by the way, you sign up to doing when you do your ADI declaration, so you're making a declaration you're going to do that, that is sometimes what's more pivotal, frankly, than the motoring offence itself. The fact that you haven't notified and recognise that you need to be compliant by notifying does not go down well in terms of the registrar's considerations of your case. So get a motoring conviction or notice of one, inform the registrar straight away, and be in compliance with that 7-day rule that you signed up to when you fill out your ADI application form or your renewal form. They'll also look at DBS checks. Obviously, they'll look at any reports additionally from any other sources from the police and the Barring Information Service. They will clearly look at complaints made to the DVSA by the public. The registrar is also allowed to access other information during your registration period. So by becoming a licensed professional, you are open to that interrogation of other sources of information about you. That's the whole point of being a regulated licensed individual. So any DVLA reporting, as I said before, any information about allegations of motoring, criminal cautions, or any convictions, any information from complainants, including the complainant's successful applications to court or a bank to reclaim money that's been paid for driving lessons. So that's more so in the case of fraud. DVSA will go looking for CCJs, any history of fraudulent behaviour, all of those kind of things as well. So they won't just draw on things like your profile with them, as in what they have on file for you already, or your tip report or your standards check performance. They'll be looking at other things to look at you holistically and see whether you are a risk to remaining on the register. A really important factor that they look at as well, people might say, well, it's a voluntary code. It might be a voluntary code in terms of you signing up to it, but it will be used in any investigation of you as an ADI professional. And if you sit in a tribunal, yet again, I'll tell you this, and it's good quality advice because I represent members at tribunals, so my experience is right at that coalface. Having an ignorance of the National Standards for Driver and Rider Training, the Industry Code of Practice and ADI regulations is not a good look if you want to be seen as a professional who is compliant and wants to be professional. So, I'm not telling you to do a cheat here, but if you ever find yourself in this situation and you haven't bothered to look at the Industry Code of Practice, the national standards, which are the blueprint for training in itself, and the ADI regs, then you better gen up on them before you sit in front of anybody upon whom your livelihood is going to defend in that situation. It's written by the ADI industry in conjunction with DVSA to ensure that it is representative and it's fair. It's clearly supported by the registrar, and it clears sound advice of personal conduct. There's many more things that those of you who are professionals think probably could be in that code of conduct, but there are a lot of things that are in there that are, fairly pivotal to doing a professional job in a professional manner when dealing with any kind of public client, never mind just in the world of driver training. So it's things like behaving in a professional manner, avoiding physical contact, avoiding inappropriate language or actions, not initiating inappropriate discussions about personal relationship, making sure that you are not misleading or misselling any of your services, management of funds and making sure you don't need anything fraudulently, complying with other codes, industry codes like Advertising Standards Authority code around advertising and marketing your business. Acquaint yourselves with those things if you haven't already. I imagine the majority of you on this webinar today know these things already, have read them, you're professionals, you're engaging in CPD. But again, we often have people try and join DIA when they're in the doo-doo. And those are the kind of people that I will find in an interview under caution with DVSA or in a tribunal are the ones who basically are shooting themselves in the foot, sitting there in this pivotal moment, telling the people who have the power to make or break your career, I don't bother to read any of the things that I'm supposed to make me professional. Never bothered reading them. I'm going to blame my audit trainer because they never told me to read them. I'm going to blame all these other people. It's not my fault, Gov. Everything's happening to me. I'm not responsible for what happens to me. None of that will help you in that situation. So make sure you not only read them in the first place, but you keep abreast of any changes. And that's, again, the value of joining professional associations and attending CPD is, keeping abreast of any changes. Again, National Driver and Riders Training Standards, they are brought to bear in things like investigations and complaints and in tribunals as well. So, an awareness, at least, if not the in-depth knowledge that I would expect you to have as a licensed and qualified professional, that I was expecting to pass on superior knowledge for which you are charging a fee to my child if you were trained to drive, never mind a regulator. So the customer is a regulator. I would expect you to know these standards inside out as a licensed professional. Certainly they are brought to bear in investigations and in subsequent appeals as well, in terms of, are you a person who even bothers to know what's in those standards, and how are you performing against those standards in terms of your standards checks? These are quite sobering figures, actually. You can look at it in one way, in terms of, the total number of ADI complaints is only 4% of the current number of people on the register. But if you look at the increase in complaints, that is quite a worrying figure. So just to put it in context here, the number of ADIs currently on the register, actually that figure there is wrong. I need to change that. Sorry, this data that I'm using here for the 41,000 is as of yesterday. It's the latest ADI stats. So ignore the 30th of the 9th, 20. That was the last time we did this presentation. And the figure there was 38,000. We're now at 41,000 registered individuals on the ADI register. The total number of ADI complaints last time we ran this particular webinar with DVSA themselves was 912 complaints in that year. So what we call the financial year of the 1st of April 2019 to the 31st of March 2020, there was 912 complaints about ADIs. As of yesterday, speaking to the registrar, getting the latest data, there is 1,700 complaints to the registrar about an ADI from the public or from other ADIs. The number of complaints that have been referred to the kind of serious guys, the fraud and integrity team, which are the guys who really do the in-depth investigations and do the interviews under conduct, under caution, that has kind of stayed the same. But there are things that won't go to the CFI team. So CFI will deal with things like complaints that involve fraud, inappropriate behavior, violence, aggression, bullying, coercion, all that kind of thing. Things to do with your standards check, like multiple failures to appear or poor performance, CFI will not be involved in. So don't look at that as a measure of, there's a massive increase in complaints, but that's not necessarily going to any kind of worrying conclusion. That is not the number that is relevant to conclusion. That's important. I'm just going to nip to I can see a question. Yes, it should be the start date is the 10th of March, 10th of June. That was the data that I got yesterday, fresh from the registrar. The date that's wrong on that slide, Ian, is the number of ADIs on the register. I need to change that. Okay, so it is a worrying upward trend. Again, don't focus on the 4% of the current size of the register. Worry about the 86%. None of us should want an 86% in complaints in the sector. And none of us should want any kind of number of complaints. It's going to happen. I'll go back to, we're dealing with human beings. I never work with children and animals, never work with human beings delivering a service, human beings receiving the service, human beings at risk if the service is not being delivered in the safest way, in the most professional way. There's always going to be cause for complaints. Now, there's an argument that have complaints risen in the last year, because this is an exponential increase. I can tell you that, we were nearer to about 1,000, 1,200 max in the last few years. We've seen a bit of a rocket zoom upwards in terms of complaints. One of the factors may well be, and that's maybe a discussion for another time, that with the current waiting times crisis, are consumers becoming more frustrated, are pupils becoming more frustrated and more likely to complain because they're not getting what they want quick enough. They're putting themselves in for tests in some situations before they're ready because of the panic buying mentality of consumers at the moment and pupils. they're failing, they're not getting the result that they want. And I can tell you a lot of complaints against ADIs come out of a customer not getting a test result that they want, or not getting a refund for, say they've bought a course of lessons, didn't read the T&Cs that says, if you fail to turn up regularly on time, try and change things in less than 24 hours, don't apply yourself properly, you ain't getting your money back, or you decide to just go off to another instructor halfway through training, those kind of things, whilst it's fair because it's compliant with your T&Cs and you made sure they knew about those T&Cs, those are the kind of things that trigger complaints. And you would not believe some of the things people will do to embellish those complaints as well, which lead to more serious alleged complaints as well. So, for example, the complaint might be, really, at the heart of it, I didn't pass my test, or I didn't pass my test in the timescale that I thought that I should be passing my test in. So I'm going to complain about you. You could think that people would just complain about that, all right? That they didn't feel you did a professional job, acted in a timely manner, made sure they got their achievement in a timely manner. For some reason, and this is human behavior probably in a lot of respects, if we go deeper into it, people don't feel that they could just make the complaint on that basis alone. They feel they have to embellish it. And that is my job, to see where I think there is embellishment and challenge that. And we will often see complaints that really at the heart of it is, I didn't get what I wanted quick enough, or it, in the way that I wanted it. So I'm going to go after you. And I just don't think that's strong enough. So I'm going to make up an allegation alongside of that about inappropriate chat or inappropriate behavior or touching or sending me photographs or something else as well. And that does happen. Sorry to scare you, but that does happen. And it's just lucky in the cases that we've dealt with that we've been able to, prove that or otherwise. But sometimes it doesn't go that way. There isn't enough evidence either side, and the ADI might just about, be okay. But sometimes they might say, balance of number of complaints, all that kind of thing. There's too many people making the same complaint about this person. It might go the other way as well. So I would worry about the rising complaints. Whether they're justified complaints or not, it's still worrying for the profession that we're seeing an upward trend of 86% increase in complaints. And as I said, don't read too much into that number of complaints referred to the fraud and integrity team, because not every removal is coming via the route of something going to the fraud and integrity team. Okay. So let's have a look now at the process that goes in terms of a complaints and investigation process. First of all, what generally happens, and is not always the case, is there is an initial complaint. So that will come from a member of the public, or they will come from a fellow ADI, not a fellow as in a friend, but somebody, maybe they were a friend at some point, but things have happened differently. Concerned professionals who want to see that everybody else is acting as professionally as them. However, there are cases of malicious complaints coming from ADIs as well. And I've seen that. I've also seen a collusion of malicious complaints. So a number of ADIs acting against another ADI because of competition, malice, not liking a point of difference in a person and wanting them out of the industry because they don't fit the mold those ADIs think they should be in. It could come from examiners in the local test centre who have concerns about a particular ADI's behaviour towards them or what they've witnessed in terms of how they behave with their pupil. It could come from a member of the public who has seen you plying your trade on the open road and doesn't like the way that you drive or the way that you interact with pupils. So that scrutiny, unfortunately, is there on you as a profession, and it comes in surprising places as well. So there is the initial complaint, and it will depend on the seriousness of that complaint. Sometimes we find out, and the member finds out about a complaint, and it is just that complaint, but that complaint is so serious, it's straight into investigation mode. There's no letter saying, we've had this complaint about you. Whilst it is of concern to get any complaint about, and I'm paraphrasing the letter, whilst it's a concern to have any body of any nature getting any complaint, there isn't enough here for us to act any further. However, the very fact you've had one complaint will remain on your file, because obviously if we get others, we need to know there's been a history of complaints here, and we'll follow it up. But no further action is going to be taken at this time. There's insufficient evidence to back this complaint up, or there isn't other complaints, or we don't think it's that serious. Or it could be that you don't find out that you have a problem until you've got a couple of complaints or two or three. This is at the heart of a problem that I have with DVSA. I would like to know myself as a professional the moment I have one single complaint. And when you send your feedback forms for anything we do, I don't go looking for the praise. I go looking for the criticism, because in that we find the things that we can improve on. I don't like this situation where ADIs aren't appraised of a single complaint against them. So you could have a complaint sitting on file about you, and because DVSA don't consider it serious enough to act on at this point in terms of an investigation, you may not be appraised about that complaint. However, what you may find is you have a few complaints, DVSA says there's a pattern here now, and actually it is concerning, we're going to investigate. Then you find out that there are a number of complaints against you. You may not even find out at that stage. If you're just an individual ADI going into this process, asking innocent questions, but maybe not all the right questions, you may not be aware that you should be asking, is there anything else on my file that I need to know about? It's my job. The first point that and Karen and others on the team who represent members in this process is just the first thing we look at is, right, okay, you've represented that there have been complaints or a complaint about this member, but is there anything else? Is there any history of complaints the member might not be aware of? Is there anything we need to know about this case? Now, the important thing here, however, is we can only represent you in any matters with the DVSA with your permission, and you must notify DVSA. I can't get any information out of DVSA just by ringing them up and saying, hey, it's Carly from DIA, give me all the gen on, whatever Matthew or Martha has done. You need to say to DVSA straight from the get-go, DIA are representing me in this matter. Can you please share all information with them? That allows us then to get into the matter and start asking the questions that, with all due respect, you may not have the experience to know what to ask. But I will be straight in there, like Columbo, asking all these questions to try and get to know whether there's any more information. Question from one of the delegates here. You can make the request to know what is on your ADI record, and I would suggest that you do that. I would want to know if there's any complaints about me on my record. So just as you can request your tip report, you can ask the DVSA registrar if there is any issues that you should be aware of. And I think I don't agree in pull messaging. I as a marketeer by background, a communications expert, I agree with push messaging. It's like the tip report. We shouldn't sit there and blame ADIs for not asking for their tip report. You should want to know what your performance is, and you should be asking for it if you're a professional who wants to see how you're achieving. But we should also be sending that out on a regular basis to people. We should be sending people information on what their performance data is looking like and what their profile is looking like. Because if you want people to act and develop and progress and evolve, you need to make sure they've got all the information and tools to hand to do that. So I think the regulator does have a responsibility to let people know how they're doing in some respects. And whilst that could be perceived as resource intensive, that becomes an excuse that government agencies make, and it doesn't really wash with people like me. You can define automatic systems that will deliver data. It's just that DVSA has terrible legacy tech systems and struggles to implement anything new and automatic reporting wise. But in the future, they will be moving to systems that will actually allow them to share more data with more regulated professionals, and so you can see more of your data, and it becomes something that is sent to you, so you and they can keep an eye on it and know what's happening. So yeah. So there will be the initial complaint or complaints. There will be a request. They will request a statement from the complainant, the pupil, the ADI, the examiner, the member of the public, whoever's made the complaint. They will be asked to submit a statement to substantiate that complaint. They can submit information anonymously, as in, you don't get to know the information and who it is, but DVSA will know who it is to be able to substantiate it's a valid complaint. They will then move to interview the instructor. So if it's a local issue that hasn't gone up to the registrar for investigation or CFI, it could be that you get asked to attend a meeting with a local test centre manager. Maybe you've had a contretemps with an examiner in the car park or another ADI. They might invite you in for a gentle chat. That's all very well, and I think that's a good way of handling things at a local level if it's not a serious thing. However, do know that if you find yourself even in that situation, you can call on us for advice and support and possibly representation there as well. So, don't feel you have to go into any situation unarmed and unsupported. Even these small things can unfortunately turn into bigger things if not handled properly. what will generally happen in complaints of a serious nature, you will also be, by the way, you will also be asked to provide mitigating evidence and a statement. So the pupil will be asked for a statement and evidence, and the ADI will be asked to submit evidence as well. Then if it's a serious enough complaint and there's enough evidence to merit a more serious process, there will be an interview with the instructor. And the interview is a pretty, intense process. It is done under the PACE Act, so the Police Act, which is, you can see the details of there. It's done under caution. It's a formally recorded interview. There is normally one or more CFI operators in there. It's a difficult one from a representation point of view, especially for someone like me, in that in your interview under caution, we are not allowed to make formal representation, unlike a tribunal, which I'll get onto in a moment. You are the person being interviewed. We are there to support you. We can brief you beforehand. We can help with things like advising that the interview is terminated if we feel it's going nowhere, you're too stressed, you're too uncomfortable, or it's going south in the wrong way. We don't think it's being conducted in the most professional manner. We can also call for breaks. So even though we can't interject and tell the interviewers anything in particular, make representation, we can kind of tap you on the shoulder and say, I think we need a break. Can we request a break? We have a 15-minute break. I brief you, or whoever's with you briefs you on, look, you're going in the wrong direction with this, or you're saying the wrong things, and blah 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 blah. We do a lot of briefing before these sessions, by the way. We don't just go in on the day. There's a lot of intense briefing going on, and so that can be quite a traumatic experience, but it is your opportunity to put your side forward. So I would always say, however stressful a situation it is, I would always go to an interview under caution. Yes, Ian, there is a Scottish equivalent of PACE. I think it broadly follows the same guidelines, but it's done in accordance with the regulations and the legislation that the police follow in any interviews under caution as well. So, do try and attend these meetings and these interviews under caution, with representation, with guidance beforehand, and a debrief afterwards, because it's not just going into it, it's the coming out of it afterwards. And I've spent many an afternoon in a rainy car park in various parts of the country debriefing an instructor about what I feel, how it went, what I think the next steps are going to be, all those kind of things. Then the CFI team will, so your interview is recorded. You can request a copy of that recording as well. And you can feed back and you can make complaints if you don't feel the interview was fair in any way as well. And that's a good thing about it being recorded. They will then pull together a report for the registrar, who will make an initial review of that interview alongside any other evidence and information about you they have. And then they will make their decision, which is generally no further action is merited. However, all of this is still on your file as an ADI, that you've had an interview under caution, that have been complaints. However, the result was no further action taken. It could result in a warning, as in, if anything else like this passes our desk ever again, you're off the registrar, off the register, or seeking representation in terms of you're going to need to go to another stage. And then there's a final review and decision by the registrar, who will then make the decision to remove or not to remove. So if they're removing, they start their process. Sometimes there is a part of the process where they will allow, if it's not a serious threat to another human being, i.e. it's not a matter of violence, physical abuse, sexual abuse, anything like that, they could allow somebody to remain teaching whilst the appeal is being scheduled. If somebody is deemed to be a risk, they're gonna tell you that you can't actually practice until the appeal is held. But generally, most people are remaining on the register and practicing until the date of their appeal. And then we go to the appeal. Then I'll talk about that in a second. The big arrow you can see across the top here is really, really important. If you are at any point in this procedure, preferably at the start of the process, when you get that initial tap on the shoulder, or even if it's not gone to DVSA, even if you had threat of a complaint being made against you by a pupil, get in touch with somebody like us and get our advice on how to handle that. I'll say this from the medical world, from the financial services world, and from this world, the common thread that runs between all of them is often a complaint that you think you are handling and has been handled can turn into being a much bigger complaint that runs beyond your control. And people are surprised sometimes that there is a complaint to the registrar about them that they think they have handled with that customer already. So customer service and managing complaints is a really key skill, because it can be the difference between a complaint being resolved to mutual satisfaction between you and a customer, or a customer still being disgruntled enough to not only complain to a regulating body and risk your livelihood and your license, or even manufacture a worse complaint about you than what the core problem was that they were originally complaining about. So, not trying to scaremonger here, because as I said, the statistics show it's only going to impact 4% of the register of ADIs, but you could be in that 4%, and you could be in there through something as, silly in a way as not handling a complaint or dismissing someone's complaint. People who feel dismissed are probably more likely going to go and complain to a registrar about something, and they'll be exasperated, and they'll be frustrated, and they'll be angry, and they'll be passionate, and emotions will run high. And that is the time in which complaints go haywire and become very different beasts from what the original complaint was. As I said, what to do if you're notified of a complaint: contact the DIA or your national association for support and representation. It is clear to both the General Regulatory Chamber, who manages the tribunals process, and DVSA that the three national associations can represent members in these investigations under caution, in any part of the investigations, and in tribunals. But you have to let them know that we are representing you, otherwise they will not share any information. It can be like getting blood out of a stone. Some investigators are really reasonable, and the registrar and his team themselves are very reasonable people, I find. There are some, being frank, older school individuals who perhaps think they're still working for the Sweeney and don't give anything away. But then that is when I would call into question whether it's a fair and reasonable process that is happening there, and whether somebody's civil rights are being undermined by not sharing information that is pivotal to their defence. You will sometimes find in this process, particularly if it's me who is helping you navigate it, I can be worse in some respects than the person that you will face at either tribunal or in an interview under caution. I am your friend in this process, but I'm going to feel like an enemy sometimes, because I'm going to interrogate you too. If I'm having to represent you and I'm having to do, all of this work on top of, the general running of the organisation and supporting members in all kinds of ways, it's going to have to be justified in terms of, are you telling me the truth? Have I got all the information? And this is to your best interest, more important than the time that we have to spend. It's hours and hours and hours of time working on these cases, and we don't charge more than the annual membership fee. If you went to a solicitor for the services, and you can, by the way, in certain cases we will suggest a solicitor rather than us for your best interest. If you went to a solicitor for the hours that we put into these cases, you would be into tens of thousands of pounds for the representation, the investigation, the work that we do. So the best policy with us is to be as honest as possible about everything from the get-go, so we can construct the best defence and the best case for you. We will also always be honest about your chances, and we will interrogate you, because that's what you're going to face in an interview and in a tribunal as well. So we have to best prepare you for that process. And sometimes people do say you were worse than the judges were on the day, but they went in very well prepared, because we'd already put you through the mill of that. And the judges are a varied pack as well. Some are very empathetic and sympathetic and helpful, and the tribunals process is for you. It's not for the DVSA. It's your opportunity. But some, really put you through the mill. And we have had occasion to complain about some individuals in that process as well. There is regulation for those guys too, and we will hold them against if we don't feel that they've given a reasonable hearing to somebody. But that's quite rare, but it does happen. So we need to really prepare you for these things. So we will be working with you to, from the get-go, compile as much information as we can about the complainant. Sometimes at that point that we're first speaking to you, we even may not know, you may not know who it is that's complaining. We will be trying to get the information about who it is, and we request that straight off the bat, and we request if there's any more complaints or anything else that we need to know before we come into interview. Again, the Sweeney type people, they really don't want to give you too much detail. They want to be able to surprise you on the day with that. That's the art of their interrogation, is to not give you too much information ahead of the game, that you can produce evidence to counteract, or produce arguments to counteract. Our job is to try and wheedle out that information and compile as much information as we can. If we haven't got names from DVSA, we will ask them to at least describe the circumstances, the year in which you were training that pupil, the months, you know, in which you were training that pupil, the geographical location. You know, although they say no, the complainant is anonymous as far as you're concerned, which they do allow some pupils to be anonymous as far as the ADI is concerned. We can at least get some identifiers to try and help us, you know, really drive down on who it is. So what we'll say to people is, you know, in this period between, you know, April and August 2012, did any pupils complain to you? Did you have any, you know, arguments with any pupils? Did any pupils suddenly exit without explanation? You never saw them again. They never turned up for lessons. You know, any issues with any pupils not passing their test, or asked for a refund, wasn't refunded, any issues, and you felt you dealt with the complaint, but they could have gone off disgruntled? So we really, you know, take people through trying to remember if there was any pupils that triggered anything that we may think they were a complainant. There also could have been some behaviours from pupils that led you to believe that whilst you think you've done a good job for them, they confided there was other things going on in their life, or they talked about, you know, having lots of problems with lots of people in their life, or lots of problems with lots of things like teachers or other people that they came into contact with their life. So there was a bit of a serial pattern of things happening to them that were other people's fault. And that might be something that triggers something in you that went, do you know what? I think it was that pupil. But sometimes a complainer will be silent. They'll just exit and not tell you, and that then will come back, and it's like, God, I thought they were happy with what I'd done, and now I find out that they had a real problem with me. So, you know, we really go back through time with you. So keeping good pupil records is really important. Being careful about what you keep in that record is also very important, because pupils can complain about the information you keep not being stored effectively and safely, or the records that they found out that you had about them had comments on them that were really unprofessional and discriminatory. So fair records, fair recollections of a training process, keeping them as long as you can in an electronic form are good ideas. And keeping diaries of pupil interactions, those kind of things, appointments, that kind of thing is really important, because, you know, these complaints can go back quite a way. You know, it might be a more recent complaint that it's easier to get hold of the information that triggers the investigation, but then they look back on your file and see that there might be complaints from as far back as 2008, 2012, 2014, and then on to the present day. You know, they're going to bring to bear those complaints as well. Now, I always make the argument, particularly in tribunal, where I'm hoping a judge will, you know, side with us on this one. If you're now bringing a complaint from 2008 to bear on this case, you clearly see that complaint as serious enough to act on. Why didn't you act on it in 2008? You're arguing it's important enough to bring to bear on this case now. You should have acted on it if it was that serious and that worrying in 2008. But, you know, we can argue that point all day long, but they will still use those previous complaints, and you might not have even aware that they existed. So, you know, interrogation, investigation, this is the Columbo bit of the process that we really get into, and at times we can be a bit hard on people as well. So that's why I say, you know, DIA or Columbo. On both sides, we are investigators and interrogators. We're interrogating DVSA as to whether they have carried out the right process, that they've acted in the right manner in terms of reacting to a complaint. Has the complaint been substantiated in any way with any evidence? You know, there's been times that I've looked at complaints and gone, are you having a giraffe? Are you having a laugh? I have just looked at these complaints and you can tell they're all manufactured. No one would have had that exact same scenario happen to them in 4 individual cases with 4 individual pupils. It just does not happen. It looks absolutely incredible. And why didn't you see this as a supposedly experienced regulatory investigation team? You know, and you know, I'm not exaggerating. There have been cases where I've gone, you don't even have to be in this world to have looked at those 4 statements and said, that's collusion. That's 4 people telling exactly the same story, and they're stupid enough to think that's going to work. And it has worked to some extent, because someone at DVSA believed it enough to bring an investigation to bear. But I'm sitting here now, and A, there's no evidence to substantiate it, and B, you cannot have this happen to this person in exactly the same way several times over. And I'll if I've got time, I'll go into a case study which was a clear case of collusion. And you would have just like me, you would have just looked at those complaints and gone, these people have conspired to complain, and they're not clever enough to have done it in a way that, you know, is convincing. So we have to investigate DVSA as much as we and their processes, and interrogate those as much as we are interrogating and investigating you yourself, to make sure you're telling us the whole story. We don't know the whole story, we can't make the best representation of you, we can't give you the best advice. So what I always say to people is, I don't want any skeletons coming out of the cupboard in an interview under caution. That's not going to help you then. You're better off being honest now, you know. And I certainly don't want them coming out at tribunal when you've applied to publicly taxpayer time in a court to have a second chance of staying on the register, and suddenly we find out you've lied all this time, or you haven't disclosed really important information, and you are guilty of the things that we've been spending time defending you against. So it's really important that we do this interrogation and investigation piece, but it's for your benefit ultimately. But we are also working to protect the public and other professionals in this process, because DIA spending lots of time on an individual who's not being honest and is guilty of some pretty unprofessional conduct is not in the best interest of the wider membership and the wider profession, nor the public as well. And we do take that seriously. We have refused to represent people on occasion because what they've done is reprehensible and there is too strong an evidence for them. We'll go in and we'll represent and we'll support and give a guidance, but there are times when you really just can't help somebody, and they shouldn't remain on the register in any way, shape or form. Okay, so, you know, bear that in mind. If you're notified of a complaint and you want us to represent you, I've already covered these points. Notify DVSA straight away. We can't do anything until they know that we are your representative. We won't automatically take up any case for the reasons I just described. But also, a good advisor realizes when they you know, a little bit like that bit of the national standards. When you've reached the limits of your knowledge and competence, you can't help the pupil anymore, so you've got to pass them on to somebody who has more competence and knowledge. That's not saying you're incompetent, that's saying there's a limit to everybody's, you know, professional competence and knowledge, and that goes for us as well. You know, so there are times when we'll say this is a criminal case, you're better off with a solicitor, and we have links with solicitors who can give you a free initial consultation for that. They're very complex cases. Second-tier tribunals, they often are where we will actually say you need a solicitor for this because you're challenging points of law in general around tribunals. These are not points of ADI regulation per se. So, you know, the best advice we can give you sometimes is to seek advice from a third party as well, who's got more professional expertise in that area. We do tend to do most of the tribunals when it comes to ADI regs and things like standards checks and things like that, and ADI world, because we have a lot more knowledge than a lot of solicitors do, because not many of them work as intimately in this world as we do. But there are cases that certainly we will advise a solicitor instead. There are some cases that can be handled under the professional indemnity and public liability policy, where your legal defence will be provided as long as your claim falls within the terms of the policy. So it's always worth checking with us with any problem that you've got that you think you need legal representation on. Does that fall into the PI policy? The earlier you notify of issues and claims, the better it is from all perspectives in terms of getting advice, but also making sure that you get representation. If you go and get a legal advisor on a claim that you then want to claim from the PIPL policy, it is the right of the insurer to refuse to cover you and provide legal defence, because you've gone and got your own solicitor and accrued costs that they may not be prepared to pay for as well. So anything like that, you report that to us, to the brokers as soon as possible, so that can be handled in the best way. Otherwise, you may undermine the policy and its ability to act for you. We'll support you throughout the process. We'll prepare you for interview, we'll prepare you for tribunal, we'll debrief both interview, and we'll advise on next steps, whether that's appeal or post-appeal, what is happening as well. What happens at interviews? I've just gone through that. Really, there's an initial meeting about less serious interviews. Complaints of serious nature subject to investigation by the counter fraud and investigations team. If called for an interview, that's normally conducted under the Police and Criminal Evidence Act PACE. There's lots of information about that online, and we will give you lots of information about that before we go into the interview. It's normally, the interviews under caution are normally done at a local test centre, but it will not be the test centre from which you operate on a regular basis. They're trying to be discreet about it, so they don't necessarily want you to go into a room where lots of other ADIs are seeing you walk through the room with some guys who look like they're quite official and what's going on there then. They try to be as discreet about it as they possibly can. So we often go in through a back door into an office to have these interviews under caution there. And I will obviously, meet with you beforehand, or Karen, or whoever else in the team is representing you. There's normally 2 CFI officers in an interview under caution, or sometimes there's 1. As said before, recorded and you can request copy. We will be present, or a solicitor will be present. We can brief you beforehand, but can't make your case in an interview, unlike a tribunal. We can make notes. We can ask for breaks to give you advice, or because we think you're struggling. And we can advise you whether we think an interview should be terminated because you are struggling too much, or we don't think the process is fair. We don't think it's going to continue to be fair. So we might as well pull out now and make a complaint that we don't feel that this process was fair and reasonable in any way. As I said before, you should make every effort to attend, and being as clear and transparent in all these processes always goes well. Notifying the registrar as soon as you think there's any problem at all is always a better thing to do than those who just try and hide it and hope it'll go away. And I won't cover that because we've already covered it. And always consult with DVSA from the get-go. You get 1 letter that tells you there's been a complaint about you. Just let us have a copy of it as soon as possible. Let us go through it. Some complaints can be headed off really, really quickly, actually. The less serious ones, or ones where it's absolutely ridiculous, and I can't believe that even DVSA has taken it seriously. Of course, you have to take everything seriously, but some of them are, this is clearly such a made-up complaint, it is unbelievable. And did you not see that when you looked at it, and why are we all wasting our time here? But the sooner we get into this process, the better advice we can give you, the more likely we are to help you to avoid the mistakes and the pitfalls, and make the positive steps that you need. Plus, it's also having someone in your corner as early as possible, given how stressful it is. So if things go south and we don't manage to mitigate your circumstances and get you out of this process, and DVSA go, don't care what you say, don't care what evidence you've submitted, don't care, what arguments you've made. We feel on balance, there's more evidence that you've done something bad and that you're a risk. We're removing you. We're starting removal proceedings. Your next stage to that is an appeal to the General Regulatory Chamber, and it's a transport tribunal. This falls into. So transport tribunals will see everything from ADIs doing and rider trainers doing, apparently bad things, to fleets operating in a serious and illegal and non-regulatory manner as well. So the team of judges on that circuit are very experienced. So what happens with that is you get in contact with us. We advise you on the likelihood of you getting an appeal. I would say in most cases, with most reasonable cases, you will always get an appeal. We will give you advice, though, if we think that you are, living in cuckoo land, that there's no point you going through an appeal process because the evidence is too strong that you actually did something bad and that you're getting removed from the register anyway. It's almost like, if you want to go for it, but it's a waste of time. We will be frank about that in terms of, the effort that's involved for you and us, quite frankly, as well. We'll keep you updated as we go through the process. We will help you make the original appeal. So to make an appeal, you fill out a form where you set out your case to the GRC as to why you should have an appeal in the first place. Please seek our advice on filling out that form, because that form forms part of what we call the bundle, the paperwork that the judges will look at, and DVSA also have the right to respond to in terms of your case. So making sure that you make the best representation, even in that original form, as possible, is pivotal in getting an appeal, but also it's pivotal in the appeal process itself. I can't believe how many cases I've gone into where the ADI has just done the appeal form themselves, through no fault of their own sometimes. They just didn't realize they could have our help with it. They've made a very scant argument, or I'm going to say it, at times an extremely arrogant argument as to why all this is happening to them and they have no responsibility for it and they couldn't have helped it, and everybody's out to get them and it's not their fault. That is not going to go down well, because what the tribunal is looking at is, are you a competent, professional, compliant person who's going to present no risk going forward? And somebody who says nothing is my fault and I have caused no risk and I've done nothing wrong, unless there's strong evidence to run contrary to that, that can itself seem like a risk. Somebody who doesn't think they're doing anything wrong is a risk if they are clearly doing something wrong. So, that can all be picked up, surprisingly, from your initial appeal application. So we can help you complete the appeal form. We'll guide you on constructing your case and submitting further information. So what happens once you've got your appeal date and you've been accepted for an appeal is, the chamber, the clerk to the tribunal will start compiling what we call the bundle. And the bundle is submissions from you, so evidence from you, written reports from you, testimonials from you, stuff that we're advising you to pull together to help your case. Evidence of any kind, text messages, screenshots, Facebook posts, anything that's going to help you in any way, that all goes into the bundle. So we must make sure that we get it into the tribunal in a timely manner so the judges can actually see it and, cogitate about it. Every time something goes into the bundle, DVSA sees it, or any new argument you want to make as a representation before the tribunal, DVSA has a right to see that and the right to respond. So you'll also see their correspondence, so they will respond as well. So that all goes into the bundle, and that bundle accumulates until we get to the actual day of the tribunal itself, and that is what the judges will have read before they come into the tribunal, and that is what we will be basing our arguments on. So we don't like to deviate too much from what's in that bundle. In very, very rare circumstances, and I have to be so sycophantic and obsequious to the judge when we're doing this, there is stuff that we sometimes bring in on the day, but we've got to have a really good reason for doing that, as in that evidence has only come to light today. And it's got to be a reasonable explanation as to why it's only come to light today. They do not like being surprised in tribunal with new evidence. And sometimes they can say, we're not going to accept that evidence. And it's a shame, but we're not accepting it because you left it too late. And there have been cases where we've done that, and they will ask DVSA if they're prepared to accept that evidence being submitted on that day or 24 hours beforehand. And DVSA sometimes reasonably say that's okay, we can do that. But sometimes the judge themselves will say, no way, Jose, we are not accepting that now. You should have got your act together and got that to either to your representative or to us in a more timely manner. So that's why the period before tribunal is really important. I will often have a Zoom call or whatever, or a phone call with you on a couple of occasions beforehand, and I'm going to be working you through. I'm going to be asking you some tough questions that I think they're going to ask you. We'll be doing some role play, so you are thoroughly prepared for going in there. Even if you say to me, I really want you to do all the talking for me, you still have to answer some questions from the judges. It does not go well for people who just sit there and want to talk through me. They want to speak to you. They want your version. You are the person whose conduct has been called into account. You are the one who has asked for this appeal to give you another opportunity to remain on the register. So you must speak up. I can make a lot of the representation for you, but they want to ask you questions and you should be prepared to answer them as well. So that's part of the preparation that we will be doing with you. A first tier tribunal, which is the first tribunal that you will apply to, and I will say, very rare that people get a second tier tribunal. Second tier tribunals are about the first tier tribunal going badly wrong and the tribunal not being carried out effectively or in compliance with legislation and regulation. So it's actually quite rare you get a second tier tribunal, or in instances where very compelling evidence has come to light subsequent to the first tier tribunal that could overturn that original decision. First tier tribunal now are, since COVID, held by secure video conference. Very rarely will you actually have to go in person, which is a relief from a travel perspective, because we used to have treks up to Manchester, Glasgow, London, and everywhere to do this. You and I, and it's not pleasant sitting in that waiting room full of loads of other people being very stressed about whatever they're going into that day. So now it's done by secure video conference. You will attend a connection test the week before. Always attend that connection test. Don't turn up at a tribunal on the day and say, I don't know how to do this, I couldn't connect, I had problems. That's what the connection test is the week before. So this is your tribunal, it's your opportunity. They're not going to keep giving you more and more just because you couldn't be bothered to go to the appointment that they told you about the week before. There's normally 1 to 3 judges, depending on how busy the GRC is at that time, because they're hearing lots of different cases. The bundle we've talked about, so they will have had the bundle beforehand. We try to get as much in that bundle beforehand so they're fully appraised of our case and any evidence, as will DVSA. But they will be going through that bundle on the day and asking you questions, so you need to stick to what's in the bundle. The registrar's representative initially makes their case. The judges are very good at the start of it. When you come on, they are, the majority, very, very good at putting you at ease and explaining the process to you and explaining it's all about you, in a way, the appeal. Then the registrar makes their representation, which is normally very brief. A summary of what's already in the bundle is their case for removing you from the register. Then you, I, or whoever makes the initial case of why we've asked for the appeal and why we think you should remain on register. Then the judges will will be asking specific questions about things that they want to pick out from your case. Then there is a final opportunity for you to make additional comments. The judge will then let you know that they will consult with each other to write a final report and pass down a final judgment. Normally, that takes between a month to 2 months. We have had cases where it has taken up to a year, but that is absolutely rare. And it came out of post-COVID and the personal circumstances of the judge involved. And we had to just keep pushing all the time. Well, where's that result? Where's that result? It's not fair for the ADI to have to wait for that result. Because the mental health issues of waiting for something like this to come down on your head and find out where your livelihood is going is huge. So, you know, I'm very passionate about trying to follow up on that. They are extremely busy. And we have some members who are still waiting for, you know, a date for their tribunal. They had an original one. They weren't able to attend it in the manner which they originally supposed to. And what happens there is you've got to get the same 3 judges together again for that tribunal. You can't just institute different judges. So getting the same 3 judges to an appointment again is really hard. So you might find out there's like a 6 month or even sometimes longer wait. The tribunal report, so you will receive the judgment as a tribunal report. I receive it, DVSA gets it, you get it. It's an official public report. It's a matter of public record. You can go on the GRC site and you can find previous tribunals, and you can find the entire tribunal itself and the reporting on that, what was said, what the appeal was. The report will tell you whether your appeal has been dismissed, as in they agree with the registrar, you're coming off the register, or upheld, as in you are staying on the register, but they believe that your case is valid and that you should stay on the register. And as I said, it's a matter of public record. So even if your tribunal is upheld, your appeal is upheld, just bear in mind there will be this public document out there about you and your professionalism that, yes, will say you have indicated, but will have information in it about you as a professional. So just be aware as a consequence, not just consequence of getting into this situation where you're even just being investigated. If it goes further, the scrutiny on you as a professional is quite great. Even if you end up staying on the register and there's no reason to remove you, there is still that information out there that you've been called into question as a professional. As I just said, these first tier tribunals, appeals to the second tier can be made if there is an issue with that first tier tribunal. It's very rare that it happens you have a second tier tribunal because of any other reason apart from new evidence coming to light that would call into question why removal was even happening in the first place, or that the first tier wasn't aware of at the time. But second tier are more about the first tier tribunal not being compliant with how it should run in terms of process and procedure, or an unfair judge, for example, a judge that didn't act in a reasonable, fair and professional manner. I've just briefly touched on consequences there, that even if you are judged to be innocent of any misconduct, any lack of professionalism, complaints can stay on your, so consequences are complaints can stay on your ADI record. Tribunal reports are a matter of public record. CCJs and things like that impact your professional and financial standing regardless. Criminal convictions, clearly there's a massive impact on your professional and personal life. This is going back to risks and consequences again. Motion convictions can jeopardize your professional career. Not turning up for a standards check or poor performance on standards checks can jeopardize your professional career. So in terms of risks to the profession, as well as road risk and general member of the public pupil risk in the everyday work, when you are in this kind of profession, not scaremongering, I'm just appraising you of the other risks in your business. These are some of the risks and consequences that you face as a professional as well. I'm probably not going to have time to go into the case studies now because we're well over time, but I will share some of these. Maybe we'll do it as a separate webinar, because I think from case studies we learn a lot. One, human nature. We want to kind of know what people have done and been involved in from a generally inquisitive, curious point of view. Two, there are genuine learnings to be taken from learning who's got into what trouble, what happened and what they did. So I'll share those case studies with you separately. And they are things that we draw on as well when we go into the next case that we have. What did we learn from that one? What could we have done better? What advice could we have given better? And how could we better prepare that ADI for that process? But yeah, those are definitely something to be learned from, and we'll discuss those. They're all completely anonymized, by the way. However, those that have gone to tribunal will, that's a matter of public record what occurred in that case anyway. Okay, so that is it in terms of the I mean, very briefly, the one that I was going to talk to you about, that in terms of, we think that we won't have a problem because we're a great professional, it could never happen to me, and I'm doing everything I can to do my business really well every day. Absolutely, I agree with you, but you could be the victim of a malicious complaint, and I've had a fair few of those, and it's absolutely devastating for that ADI to be in that situation, and the guys that it happens to, I really feel for them, because it's a personal assault as well as a professional assault, that somebody would make that stuff up about you, and some of it is utterly disgusting what somebody is prepared to say just for you not getting them past their driving test as they think that you should have done. I mean, forget that it's their responsibility to get themselves through the driving test, but they will blame you, and they will embellish their complaint, and they think they have to go to the extreme of saying, Andy touched me, Andy talked dirty to me, and she sent me indecent photos, and she was verbally aggressive to me. One of the cases that sticks in my memory the most is fairly early in my time at DIA, was a pupil failing his test and demanding a refund for a package of lessons that he's paid for, because he was blaming the ADI. It's the ADI's fault that I didn't pass, so I don't want any more lessons with him. I don't want the balance of the lessons with him. I want to go and get my money back. ADI refused because they had clear T&Cs that it was a package of lessons. There was no refunds. The pupil was consistently late. There was something in his T&Cs about that. There was no shows. He was an unreliable pupil. He was aggressive in his manner. He was actually quite difficult to teach. So the ADI enforced the T&Cs and said, no refund, and actually I'm refusing to carry on teaching you. The pupil colluded with his cousin, who had actually originally recommended this ADI and had a great result, which we used in the tribunal and in the evidence, that the cousin, who is now colluding to bring a complaint of a sexually inappropriate nature against the ADI, had written testimonials on Google and everywhere and referred his cousin to this trainer. Now, wouldn't you call that into question? You said he was such a great guy that you put it all over Google, and you also said to your cousin, go and have him. If you're now saying he was sexually inappropriate with you, why did you put your cousin at risk and tell him to go to him for training? And why did you go and put him all over Facebook and Google? So that didn't stand up to the test of what is a reasonable piece of evidence, or a reasonable complaint, or a credible complaint. So the pupil, the original pupil who'd failed his test and wanted a refund and was disgruntled, manufactured a complaint that the ADI had been sexually inappropriate with him. He got his cousin to do the same, the cousin who recommended this ADI, and about 3 other male friends were asked and conspired to produce complaints and make complaints to the DVSA about this ADI, about being inappropriate lessons. By the way, all of the other people who made complaints, as in the pupil who made the original complaint, the cousin who'd referred, and the 3 friends, had all been referred by the original guy. So this guy had, either he's part of a grooming ring and he's recruiting people to this ADI. If this ADI really is sexually inappropriate, or he is, they're colluding. DVSA, for some reason, decided to follow up on this complaint. Clearly, they have to. I'm not saying it's for some reason. That seems really undermining. They have to. It's a serious complaint. But when you actually looked at the complaints themselves, the written statements from the pupils, they were all the same. Exactly the same thing happened in every single incident and lesson. That is just not credible. The same words, the same actions, the same context, the same conditions. That it wouldn't happen. Yes, we all know from watching solving a lot of murders on Netflix, we all know there's an MO of people, and people follow an MO, but exactly the same thing happening in the same way, in the same conversations, the same things happening is just not credible. We then discovered, because that obviously piqued our interest, we then did more investigation. We found Facebook posts. We really worked the ADI to say, go back through your text, go back through anything, find anything from parents, from pupil, from whatever. And there was text that he had where there was threatening text that says, from the original complainant's mother, there's things that can happen to an ADI if they don't do what we want that are very unfortunate. We can make stuff up and make your life very difficult if you just don't give us the money back. So there was, collusion to complain, and there was more evidence that we were able to bring to bear that resulted in the complaints being dismissed and the ADI remaining on the register. Didn't stop it being an extremely traumatic process for the ADI. A lot of investigation to undercover that information. investigation you would have hoped that would have been done by DVSA themselves, but ends up being our job 9 times out of 10. And there's other cases that we've had more recently, like missed standards checks. People who have had a series of unfortunate events, meaning they missed multiple standards checks. DVSA deemed that was a person who was basically evading standards check. They had submitting evidence of reason for missed appointments. DVSA claimed they were insufficient in terms of evidence. The ADI appealed. We compiled a lot of evidence that even the ADI didn't realize they had until we worked them over like Columbo to make sure that they had everything that we should have for an appeal. And when we represented and carefully constructed a case on his behalf, it demonstrated that he had good reason for every single instance of the standards check that he'd made. He'd made every effort to comply, and that he wasn't at fault. And the DVSA case was judged not to be robust enough for removal, and the judge felt they'd been unfair in their removal proceedings, and the appeal was upheld, and the ADI was not removed from the registrar. They did have a standards check very quickly afterwards, which the pressure was really on them to perform in, but that's where we were able to be successful in that. So last thing I'm going to talk about is just campaigning. I know we've really gone on here, but I think it's an important topic. So thanks for remaining with us, those that are able to. The rest of you can watch this as a recording afterwards if you have to go. We not only make this representation and help our members with cases such as these, we're also lobbying and looking at and discussing with DVSA, who I would say are more open than ever and more willing to work with us to make sure that we can make the world a better place for everybody. Our work is to ensure trainers are appraised of their rights of representation, what's going to happen in this kind of process. The best thing we could do is appraise you of the risks and how to mitigate them so you don't even get into this situation in the first place. And even if you are an innocent party, appraise you of the risks of you being called into question through malicious reasons. Lobbying DVSA for clearer guidance on the processes is really important. The one thing that I've asked for as well, and I'm not sure we can ever get to this point, but for those people who commit perjury, who lie and make up malicious complaints, where are the penalties for them? For false allegations and falsifying complaints and putting somebody through this process, where is the penalty for the pupil? So that's one of the things I am lobbying on, is I think there should be some kind of penalty. If a pupil throws a brick, as they have done, through a test centre window, or is aggressive or violent towards a DVSA examiner, they aren't allowed at that test centre again. If somebody does something aggressive, abusive, or makes malicious complaints that not only waste DVSA resources and time, but also ruin someone's career and their mental health, where is the penalty for that person? And I think the regulator has a responsibility there as much as they do to protect the public from unprofessional trainers as well. And the other thing that we're very keen to do is educate trainers in general. So education is really important as a risk mitigant. If we're enforcing, someone somewhere has already been harmed. I'm just going to go quickly to your questions for those of you who still remained with us. Last question. No, unfortunately, you can't sue. Well, you could sue, but that would be a civil matter for you to undertake at your expense, which is, something that is an issue for many ADIs to actually go through that process. And again, it's a very traumatic process to go through. The appeal process is one that we hope sorts out the issue, but obviously that will never, even if you're vindicated, it won't replace the emotional trauma and the professional reputation issues that may result from that whole process. But there is a lot to be done in this area, and it is an area of great concern to me. So there's a lot of conversations that I will have when we meet with DVSA about what can we do to make this better, fairer, and where are the penalties for the pupils in terms if they perjure themselves to make a complaint. Okay, so that's an old slide. So after this session, I'll go into Q&A in a moment. Consider the risks and what measures you can undertake to mitigate them to safeguard you and your pupils. So safeguarding training, sorry if it sounds like I'm pushing CPD here, but it's a fundamental flaw in the ADI qualification process. You're one of the only training professions that works with young and vulnerable people that doesn't have safeguarding as a constituent part of the qualification. So if you haven't already done safeguarding training, please look at doing it, because not only is it designed to protect the pupil, it's designed to protect you, the professional. Understand what fit and proper is, understand what the ADI regs relate to in terms of you and your career, understand how the standards can be brought into account as well as in terms of your professional conduct, understand what all the risks are and how you can best mitigate them. In terms of, yes, you can say, how do I mitigate the risks of someone making a malicious complaint? sometimes malicious complaints come out of a customer service issue or a complaint that you didn't think that was serious, that you didn't handle very well and didn't handle to the satisfaction of the customer. So ensuring when there's a complaint at your level, you handle it to the mutual satisfaction is great, especially if you make things like goodwill gestures and things like that. Making sure that people goes away happy is important. Appraise yourself of the code of conduct and the fit and proper process, and keeping records and diaries and maintaining those as electronic records predominantly, so it's easy for you to store, is really important, because some of these complaints can be really historic and we can't rely on everybody's memory to go back that far. And remember, ignorance is not an excuse. Is sitting in there and saying, I didn't know that was, I didn't know not to put my hand on someone's knee so they could feel the clutch point. I didn't know not to put my hand over the pupils on the gear stick. I'm telling you now, you have very little cause to touch your pupils. You know that, we know that, but people sit in interviews and say, oh, I only did that to demonstrate this. Well, it made the people so uncomfortable that they complained. And physical touching is in the code of practice. You shouldn't be doing it. There's no real reason other than extreme emergency measures, as in, maybe the only thing is throwing your arm across somebody if you think you're going to have to stop in an emergency situation. But even then, that's not necessarily acceptable behavior. So inappropriate chat, inappropriate, talking about relationships, your relationships, their relationships. Yes, you've got to form a relationship with the people, but you don't need to interrogate their personal and private lives. If they're disclosing stuff to you, that's a different matter. And that's what safeguarding training is very useful, is handling those disclosures and handling those conversations to make sure that they don't become unprofessional as well. Thinking about the risk, considering changing what you do if you feel like it needs change, how you think and how you behave in the context of what is fit and proper, in the eyes of what you would see the public and the regulator and the tribunal it sees as reasonable behaviour, not your personal and subjective opinion of what is fit and proper behaviour. Is what standards would you expect from another professional, and what is right to do as a trainer and what is very wrong to do as well. So yeah, we have people who are of an older vintage, shall we say, of driver training, who are mystified that they are in an interview under caution for continually putting their hand on the knee of a pupil to feel the clutch point, or their hand on top of the pupil to hear the gearbox. Pupils don't like it. They don't want to be touched. You're invading their personal space, and they have a right to complain about that if that happens. Same with intrusive personal conversations or off-the-cuff comments or texts outside the context of training or Facebook posts that you make. A lot of the cases I'm seeing now are to do with behavior by ADIs on social media or via WhatsApp. Don't believe it's encrypted, so it's secure. Honestly, it's not secure enough for people not to be able to take a screenshot of it or a photograph of the phone or forward a message. So these things are increasingly brought into evidence. ADI groups, WhatsApp groups of ADIs, talking about pupils in an unprofessional manner, are brought to bear in cases to remove the ADI as non-professional conduct, talking about pupils, examiners or DVSA in a derogatory manner in what you think is a closed or private group. Unless you are a skilled operator in the context of the dark web, lots of things can be found out and used against you in terms of removing you from the register and calling into account your entire professional career and licensing. So do not make the mistakes of being unprofessional in any context where you're online and effectively publishing things, or in a WhatsApp group, however securely encrypted you think it is, Telegraph, Signal, whatever service you think you're using. No one is beyond being found out in that context as well. So that's a very long session this morning, but it's a really big subject. And as I said, going back to that statistic that, complaints are on the rise, and trying to comfort yourself that it's only 4% of the profession that will ever be at risk of this. That percentage is going up. Complaints are on the rise. Some of it is a terrible thing because it's just down to customer disgruntlement about not being able to get tests in a timely manner or passing in a timely manner. It doesn't matter whether it's justifiable or not, it's still a risk that you're going to have to handle. And it'll either be a big thing to handle and result in something hugely threatening to your career, or it'll be a little thing, but the little thing takes a lot of time and a lot of stress to deal with. So it's better not to have to deal with that in the first place. And if you do have to deal with it, know that there is some help. We can't wave a magic wand. We can't get you out of trouble if you've done things to really get yourself into trouble, but we can help mitigate those risks and help you through the process. So give us a call as soon as you've got an issue. The initial channel to go through is to email support@driving.org, our help desk, or call the help desk. The sooner you do that when you've got a problem, the sooner we can intervene and assist you in any way that we can. So that's it, really. Is there any final questions or comments from people, or have I scared you into silence today? Very happy to stay on board for a few minutes if anybody wants to chat. Otherwise, you can just reach me via DIA or via the support desk. And if you've got a concern, you want to speak to somebody one-on-one, I'm very happy to jump on a call with you, jump on a Zoom and talk you through whatever is worrying you at this moment in time. But otherwise, in the best of ways, I hope to never speak to any of you on this call in this context. But if I do have to, know that we will do our utmost to support and guide you through that process, and hopefully reach the positive conclusion that you'd like to think that we could when it comes to these issues. So thank you. You can get in touch. People asking how you can get in touch with me. You can get in touch with me directly via Carly Brookfield, CARLY, like Carly Simon. Carly Brookfield at driving.org is my direct email address. Give me a little bit of time to respond, because obviously I've got quite a lot of inquiries, like yourself, busy people, but I do try and get back to people in a 24-hour time window. May refer you at times on to one of my other colleagues in the team on the help desk, because they might have more knowledge in a certain area than I do. But the real channel to help and information quickly is to use the support@driving.org email. And just know that we are doing our best as well as a lobbying and representation body to try and fix some of the issues within the process and procedures as well, and make sure that it's a much fairer and reasonable process for professionals when they're going through this too. Okay, thank you everybody. Thanks for attending. It's really rewarding to see those of you giving up some of your time today to do that. It is an important subject. I don't want to scare you, but I think forewarned is forearmed. And despite the slightly gloomy nature of the chat today, I hope you go on to have a very bright and safe day. Thanks for joining me today.